Good afternoon, sir. Emmanuel. Introduction. The Central Information Commission, the statutory body which looks into complaints and appeals that citizens can file when they don't get the information they want after filing an RTA application. Basically, the Right to Information Act gives people the right to inquire about various public information like the salary of a certain minister or how public funds are being used, etc., by submitting an RTA application. CIC is significant because it gives the citizen a platform to appeal they have not got the information they wanted. CIC was established by the central government in 2005 under the provisions of RTA Act 2005. The Information Commission consists of a Chief Information Commissioner and not more than 10 Information Commissioners. Their control extends over all central public officials and their decisions are final. The members who are appointed to the CIC must have wide knowledge and experience in law, science and technology, social service, management, journalism, mass media or administration, and governance. The Chief Information Commissioner or the Information Commissioners should not be a member of parliament or member of legislature of any state or union territory or hold any other office of property. He also should not be connected with any political party or carrying on any business or pursuing any profession. Each Information Commissioner carries out a term of 5 years and cannot be reappointed. Current issues with the CIC. It is estimated that around 50 lakh RTA applications are filed each year, but only a paltry 43% of people receive the information they want. In addition, as of 2019, there were 2.18 lakh appeals and complaints pending before the CIC. This indicates that it takes a while to dispose of a case. In fact, the national average to deal with the case is over a year, highly influenced by when the State Information Commission of Andhra Pradesh took 18 years to dispose of a complaint. But that's not all. The government is keeping it this way by not improving the infrastructure and keeping posts vacant, which leads to understaffed offices. Over to Antony.
The RTA Act of 2005. The Parliament of India passed the Right to Information Act in the year 2005, which is the legal provision protecting the Central Information Commissioners. This act gives all Indian citizens the right to acquire information about any public authorities, except for confidential or information that is affecting the national security. The act aims to encourage citizens to create a transparent environment for the proper and ethical functioning of public authorities, to make them answerable to the public and to uproot corruption. Members of CIC are appointed by the President and the suggestions are given by the Appointment Committee, which consists of the Prime Minister, a Union Minister appointed by the Prime Minister, and the opposition leader in the Lok Sabha. The opposition leader being part of this committee is very important, as he ensures that not just the political interests are satisfied. The amendments made to the RTA Act in the year 2019. Recently, the government passed certain unfavorable amendments to the Act. The central government is authorized to introduce recent changes made to salary, allowance, and other terms and conditions in return for the service rendered by the Central and State Information Commissioners. Both Central and State Information Commissioners are placed in the same pay scale as civil servants. A ranking was formed as the Information Commissioners were paid less than the Chief Information Commissioner. So to avoid such rankings, this was intentionally dropped in the original act. The central government also introduced certain rules. Few of them are Rule 21, which gives central government the authority to alter any rules that is not mentioned in the amendment. Rule 22, which gives the central government the authority to control any rules regarding a person's class or category. And finally, Rule 23, which gives central government the ultimate and final authority to decide on inference of these laws. Now, Arya would take you through the next slide.
I will now take us through two relevant cases where the RTI Act was misused. The first has to do with the PM CARES Fund. The fund was established on 27 March 2020, and during the year, it collected 3,076 crore rupees in funds. People wanted to know more about the fund, but there was no information on the website, or rather, there wasn't enough. And as a result, they all filed RTI applications. In response to those applications, the Prime Minister's office said that they would not divulge any information because the fund was not considered a public authority. So let's look closely at the Act. Under Section 2 of the Act, any body owned, controlled, or substantially financed by the government is considered a public authority under the ambit of the Act. In the NSC case, the Delhi High Court demonstrated that a body need only fulfill any three of these conditions and not all of them to be considered a public authority. And in a response to an RTI application, the government admitted that the fund is owned and controlled by the government, but since it is not financed by it, they didn't consider it as a public authority. So as we can see, this is a clear and absolute violation of the law as laid down by the Delhi High Court. The next case has to do with parliamentary privilege. In 2011, Subhash Chandra Agarwal filed an RTI application to know more about the tenure of the Secretary General of the Lok Sabha, but he didn't get the information he wanted. So he appealed to the CIC. To decide the tenure of the Secretary General of the Lok Sabha, there would have been discussions among the Speaker of the Lok Sabha, the Leader of the House, and the Leader of the Opposition. And the matter of conflict is whether the information discussed during these discussions was confidential or not, and whether it came under Article 105 of the Constitution, which has to do with parliamentary privilege. The Information Commissioner handling Subhash Chandra's case handed over the case to the Speaker of the Lok Sabha because the Speaker would know more about the information that got discussed in these consultations and whether that was confidential or not. In the end, the Speaker of the Lok Sabha decided that the information was confidential and should not be disclosed. Subhash Chandra took his case to the Delhi High Court, and the court ruled that the information was not exempt under the parliamentary privilege and that Subhash Chandra's statutory right to information should be upheld. The court further penalized this information commissioner for handing over the case to the Speaker of the Lok Sabha and not doing his own job. Over to Joe.
Now let's see the impact of the new Amendment Act 2019 and Rules 2019 on the constitutional democracy in the country. Loss of independence of information commissioners. The independence given to the information commissions under the RTA Act of 2005 was taken away by the introduction of the Amendment Act 2019 and Rules 2019. Unfair reduction in salary of commissioners. The wages and allowances of state information commissioners are not funded by the central government, but out of the respective states' consolidated fund. As a result, the center's entire control over the salaries and terms of the state information commissioners destroys the federal character of the constitution and is considered unfair. Compromise of federal structure. The federal character of the Constitution, which is its essential structure and is considered law, over which Parliament has no jurisdiction to modify, is violated by the centre's control over the state information commissioners. Violation and undermining powers of the Parliament. The planned motive to lower the powers and level of independence of information commissioners were not even disclosed to the Parliament Houses Rajya Sabha and Lok Sabha, which is a clear violation of the parliamentary privileges. Violation of the pre-legislative consultation policy of 2014. Both central and state information commissioners and other stakeholders were not consulted prior to the Amendment 9 rules. This is a clear violation of the 2014 pre-legislative consultation policy, which mandates that all draft rules be made public and open to public criticism and recommendations. Over to Hridayesh.
Now let's look at the way forward. The basic issue here is that the government imposed restrictions on the information commissioners which impact their independence. The information commissioners termed this as killing the spirit of the RTA. The way forward for the information commissioners look bleak. They have lost their independence and are reduced to nothing and are replaced by bureaucrats. The special privilege of the information commissioners are gone and they are reduced to nothing more than any other bureaucrat or puppet in the hands of the central government. Since state and central governments do not prefer an all-powerful information commissioner, they have taken all the steps necessary to reduce the power of the information commissioner through red tapeism and bureaucracy. Since the independence is gone and the states and centers do not want a law-abiding information commissioner, it is highly unlikely that they would get their independence and status back. Now, suggestions for redressal. Though the entire amendment cannot be revoked, certain key aspects that affect the Constitution of India can be revoked, reducing the influence of central government. So, as per the recent amendment, the salary of the Chief State Information Commissioner and the State Information Commissioner can now be fixed by the central government, thus reducing the power of the state and ruining the federal structure of India. This provision can be revoked, and the power to fix the compensation of the state officials can be given back to the state government as the salaries are anyway drawn from the state fund. Effort should also be made to improve the infrastructure and to avoid keeping vacancies. Now, salary and benefits. The amendment revoked the provision which granted the information commissioners a fixed salary equal to the concerned election commissioner and a guaranteed tenure of 5 years. Now, the salary and the tenure of the information commissioners are at the discretion of the central government, which makes the information commissioners mere puppets in the hands of the central government. At least the provision relating to the tenure of the information commissioners can be revoked so that they can perform their duties without being fear of fired at any instant. Conclusion. The right to information law has converted India from a defective elective democracy to a participative democracy. Right to information, which is the fundamental right of every citizen of India, is currently under threat. The new amendment is a menace to the prime objective of the 2005 RTA Act, which was to ensure transparency and accountability in the administration. It is thus now safe to say that the central government, by taking away the authority, independence, and autonomy of the information commissioners, has made them their puppets and butchered the soul of the RTA Act and also ruined the federal structure of India. Thank you.